Alright, first comment. Statute is so vague that it leaves too much up for officer discretion. Then I added, also the victim is left to guess what that discretion might be. There's a difference between police officers and cops, and I would also add soldiers as well. Louisiana ID law doesn't give the officers a right to ID me, especially when I told them what I was doing, and the officers only used the failure to ID as a reason to arrest. The officers can't conjure up something after the arrest because if they did, it would be considered fruit of the poisonous tree, illegal. Officers with reasonable articulable suspicion of a crime and detaining someone can demand ID, but the statute does not say it is illegal not to provide it, and nor does it assign a penalty for not IDing. It's quite a stretch to apply resisting to not IDing under the law. Failing to present ID, although no crime was articulated, is resisting an officer to these cops. If there's no potential crime involved, then unusual behavior isn't suspicious and isn't enough to justify any intervention or interaction by authorities. Behavior that isn't necessarily common, understood, or desired is not the same as suspicious in a legal sense. Refusal by the arrested of detained party to give his name references nothing about police have the right to ID law-abiding citizens whom committed no crime or suspected of. Had officers legally detained him and Travis refused, then that law would be legal to arrest. In order to be arrested or detained, there has to be reasonable articulable suspicion that a crime has been or is or will be committed. He was neither arrested nor detained at that point. All we get is meaning we have a reason to talk to you. They do have to articulate the detainment, otherwise police could just randomly ask for ID, arrest, and then say later, detained, but we didn't have to share that with the victim. Nice lawsuit, as they violated Section 242 of Title 18, making it a crime for a person acting under color of any law to willfully deprive a person of a right or privilege protected by the Constitution or laws of the U.S. The Louisiana law states under Article 215, temporary questioning of a person in public places. A law enforcement officer may stop a person in a public place whom he reasonably suspects has committed or is about to commit an offense, and may demand of him his name, address, and an explanation of his actions. I was kidnapped by being detained in an area in which nobody would expect me to be, at jail. Lieutenant Stan Williams saw nothing wrong with how his subordinates acted. My actions in the library prior to the video justified the police actions against me. I did not resist arrest because the charge is not resisting arrest. Rather, it is simply resisting. So I was charged with resisting the officer's questions or failure to identify. Put simply, that is not primary crime, and it only applies after you have been arrested. Police must have reasonable suspicion, but they don't have to share it with the suspect. They suspected he might have dangerous weapons in his backpack and be casing the exits in preparation for a crime, assault or burglary. That's likely enough reasonable articulable suspicion, of a crime to temporarily detain. See the police report. They left out a few facts in their reports. Acting weird is not a crime. Also, I too check where the exits are and impress upon my kids to do the same in the event of an emergency. Lastly, it is also not illegal to conceal contents of one's personal belongings, otherwise all bags would be see-through. Based on this decision by the Fifth Circuit, police officers can't arrest a person for refusal to produce identification if there is no reasonable suspicion of a crime on the part of the individual who won't produce identification. Lieutenant said that he scared the elderly white ladies who work at the library. If you detained, you have to tell the police who you are. He was rude to the elderly ladies. They arrested you unlawfully because the 25-year-old LEO was impatient and didn't know the law. It took 2 minutes, 40 seconds for them to lose their patience and arrest him when, 1, they never established an actual crime, 2, they never established the elements required in subsection C, specifically arrested or detain. Nothing in the police report constituted reasonable, articulable suspicion of a crime. Officer Davis is the complainant. You were not arrested or notified, you were detained. And all indications were officers were engaged in a casual conversation and had no reasonable suspicion of a crime. RS 14108 clearly says arrested or detained. A law enforcement officer may initiate a Terry stop when he or she suspects that an individual is committing, but probable cause does not yet exist to arrest, and the officer wants to stop the suspect and investigate. Natchitoches PD says Hines was legally detained because of the reports regarding his suspicious behavior in the library and his refusal to provide identification. Criminal suspicion, an objectively justifiable suspicion that is based on specific facts or circumstances, and that justifies stopping and sometimes searching a person. Suspicion is not a crime. Suspicious activity is not a crime. A suspicious person is not a criminal. It only allows the officers to make contact. After they have made contact, it is up to them to investigate. It is not your duty to help them. A defendant's motion for a speedy trial must be accompanied by an affidavit from the defendant's counsel certifying that the defendant and counsel are prepared to proceed to trial. FOIA the dockets. Ex parte for Feb 15, keeping you there until May causes hardship for someone who doesn't live there. A court will decide whether the stop was lawful at a later date. Cops must investigate. Cops must have a crime. Cops must tell the person of said crime. You must ID. Cops must arrest or give ticket. It must always be in this order. Failure to ID or resisting arrest are secondary charges. Suspicion is not a felony or misdemeanor. Civil rights supersede any town ordinance or policies. Terry v. Ohio stands firm. A citizen does not have to identify unless an officer has reasonable articulable suspicion or facts of a crime committed. A citizen does not have to identify for a detainment or because an officer asks for your ID. The Internal Affairs lady said that a pedestrian can't be stopped out of the blue and arrested for not showing ID. But to the pedestrian, the stop is out of the blue. Cops cannot just walk up on a person and demand their ID for no reason. But a caller can give reason. Another citizen can take away your rights, but law enforcement cannot. Supreme Court of Louisiana, State of Louisiana v. Timmy Hill. Even assuming that the Terry stop was unlawful, the discovery of outstanding arrest warrants constitutes an intervening circumstance which dissipates the taint of such initial police misconduct. Due judicial notice for Federal Rules of Criminal Procedure 5.1. To question the constitutionality of the statute and a judicial notice of civil rights violations, you must have those on the records for appeals. There is no such thing as suspicion. It is an emotion. The court cannot prosecute nor sentence anyone for this emotion. If the court cannot use it, then why can the police use it as part of their argument to deprive people of their liberty? Suspicion is subjective. Obviously, someone was being nosy. She was mad she couldn't be nosy and see my things. That's weird. For Louisiana Lars 14108 B1C obstruction to be a secondary criminal offense, Jordan, La Quinta, and Thorman must first find that a crime has happened. There needs to be reasonable suspicion or a good reason to believe you committed a crime. They skipped right over articulating a crime or a detainment. Johnson v. Thibodaux City, 2018, Fifth Court limits for an officer. Police can't arrest a person for refusal to produce ID if there is no reasonable suspicion of a crime on the part of the individual who won't produce ID. Miller v. U.S. Fifth Circuit. The claim and exercise of a constitutional right cannot thus be converted into a crime. Brannon Trahan v. City of Scott. I think he was a private investigator who got harassed by cops. You need to know that you are being detained, because it's clear when you're being arrested and placed into handcuffs, but it's not clear when you're being detained because there's no handcuffs for that phase. Article 218, Method of Arrest. A peace officer shall inform the person to be arrested of the cause of the arrest. Rosalind provided hearsay of male acting weird. The standard for reasonable articulable suspicion of a crime is lower than probable cause. Almost anything from the cop will suffice to meet that standard. The elements the prosecution is likely missing is willfulness. You did not refuse to ID just to resist or obstruct cops. You refused to ID because you believe you had the lawful right to not give ID. They never told you that you were detained, but you didn't ask either. Louisiana Constitution, Section 5, Right to Privacy. Every person shall be secure in his person, property, communication, houses, papers, and effects against unreasonable searches, seizures, or invasions of privacy. From the arrest you restate there is no crime. Miller replied, okay, you're under arrest. Even if you were considered detained, it was not for a crime. You only have to ID when detained or arrested for a crime in Louisiana. So you obstructed an officer while detained, but not officially detained, and not detained for any crime. You were detained unlawfully, at least from the moment Davis told you to keep your hands out of your pockets. If they are stupid enough to use "we got a call and you matched the description" as reasonable articulable suspicion of a crime, they probably used that reasonable articulable suspicion the moment they saw you with their eyes. Police persecution is how something as a simple detainment by police, when one is innocent of any crime, have an entirely different view of their rights as the police might have. For if indeed the law is violated simply by a person protesting or arguing against the detainment, being for their innocence, to protect their innocence, such protests might be seen by the police as a violation of the law or resisting arrest, and so an arrest is made. This then may be the cause of so many innocent people behind bars. If we consider innocent as meaning they did no crime but did indeed protest their detainment, which really should not be illegal. Fifth Circuit Court of Appeals. Reasonable suspicion must be based on objective facts. As in the cops, what facts did you observe that led to a reasonable suspicion of criminal activity? The cops need to see something themselves, it seems, not just go by what some caller said. All they really have to prove is intent, and you're recording the encounter, then later publishing it as a pattern of monetizing your interactions with the police makes the case for them. If you were detained, it was a violation of your rights. If you weren't detained, it was an unlawful arrest, a violation of your rights. The officer must have sufficient facts within his knowledge to justify an infringement of the suspect's rights. An inchoate or unparticularized hunch or mere suspicion is insufficient to establish reasonable grounds to stop a person. State v. Tucker and Leary. In order to assess the reasonableness of an officer's conduct, it is necessary to balance the need to search or to seize against the harm of invasion. State v. Stewart. Whether an officer has a reasonable suspicion to make an investigatory stop should be determined under a totality of the circumstances in light of the officer's experience, training, and common sense. The officer's experience may be a consideration in ascertaining whether his inferences from the given facts were reasonable. State v. White. Flight, a furtive gesture, nervousness, or startled behavior at the sight of a police officer is not by itself sufficient to justify an investigatory stop.